Take a common commercial dispute. Arcos Limited is contracted to build for Berry plc. Midway through, Berry promises a £10,000 bonus to ensure the project finishes on time. Later, they attempt to settle the final bill by paying £5,000 less than the agreed total. To resolve this, we have to fill these 4 empty brackets: the issue, rule, application, and conclusion. Solving this scenario requires unpacking 3 distinct legal crises. We have an upward variation, a promise to pay more for the same work. We have a downward variation, a promise to accept less to settle a debt. And finally, we have the question of who actually has the right to enforce these promises. English law demands a reciprocal exchange. Just as these abstract shapes must interlock perfectly to create a stable structure, a contract must be a bargain. To find that bargain in the Arcos scenario, we have to look for the specific currency that makes a promise enforceable. This is the doctrine of consideration. In 1875, the court in Curry v. Misa provided the standard definition. Consideration is either a benefit accruing to one party or a detriment suffered by the other. It is the price paid for the other party's promise. However, the law distinguishes between economic equality and legal value. Courts do not ask if a deal was fair. The rule is that consideration need not be adequate, meaning it doesn't have to match the market value, but it must be sufficient, meaning it holds some value in the eyes of the law. We see this in Chappell & Company versus Nestle. Nestle offered a music record for a small fee, plus 3 discarded chocolate wrappers. The House of Lords ruled those wrappers were part of the consideration. If a party stipulates that a peppercorn is the price for their promise, the law will enforce it, regardless of its monetary worth. The sequence of events is also critical. In Roscorla versus Thomas, a horse was sold, and only after the sale did the seller promise the horse was sound. When the horse proved vicious, the buyer sued, but he lost. Because the purchase happened first, it could not serve as consideration for a promise made later. Past consideration is generally no consideration. There are rare exceptions, as seen in Lampley versus Brathwaite and Re. Casey's patents. For a past act to be valid, it must have been done at the promisor's request, with an understanding from the start that it would be rewarded, and the payment must be of a type that would have been enforceable if promised in advance. Consideration is the mechanism that filters the thousands of promises we make daily, identifying exactly which ones the state is willing to enforce. This brings us back to Arcos. They were already contracted to finish the project. Can they illegally claim that extra £10,000 bonus for simply doing what they were already obliged to do? This matrix separates contract alterations into 2 distinct categories. On the left, upward variations involve a promise to pay more. On the right, downward variations involve a promise to accept less. For upward variations, the starting point is Stilk versus Myrick. When 2 sailors deserted a voyage, the captain promised to split their wages among the remaining crew if they worked the ship home. The court refused to enforce it. Since the sailors were already contracted to handle the normal emergencies of the sea, they had provided no new consideration. That rule stood until Williams versus Roffey Brothers. Here, a main contractor promised extra money to a carpenter to ensure they finished on time, avoiding expensive late penalties. The Court of Appeal ruled that because the main contractor gained a practical benefit, avoiding those penalties, the promise was binding. In our Arcos scenario, Berry plc promised the bonus to avoid their own delay penalties. Under the Roffey rule, that avoidance is a practical benefit. Arcos has a legal right to the £10,000. The law evolved here to recognize that in commercial construction, the value of avoiding a specific, costly delay can be just as real as the initial exchange of goods. Now we must address the second half of our scenario, Arcos agreeing to accept £5,000 less than the full debt. In this column, we hit the rule from Folks versus Beer. It states that part payment of an undisputed debt is not sufficient consideration to forgive the rest of the balance. Logic might suggest we could use the practical benefit rule from Roffey here as well. After all, getting some cash now is practically better than chasing a debtor for years. But in Select Move, the Court of Appeal admitted they were stuck. Folks versus Beer is a House of Lords decision, and lower courts cannot simply ignore that higher precedent. Because the House of Lords has never overruled Folks, The RAFI exception for practical benefits is restricted to promises to pay more. It cannot be used for promises to accept less. At common law, the debtor is still liable for the full amount. When the rigid hierarchy of the common law leads to a dead end for the debtor, we have to look toward the alternative system, equity. Equity provides the doctrine of promissory estoppel. This prevents a creditor from going back on a promise to accept a smaller sum, even if the debtor provided no consideration, if doing so would be unfair. This doctrine was born from the High Trees case. In 1940, wartime conditions and the Blitz left flats empty. The landlord agreed to halve the rent to help the tenants stay. When the war ended and the landlord tried to claim the full rent for the war years, the landlord was stopped. He ruled that while there was no consideration for the discount, the landlord was estopped from going back on their word. This requires 4 conditions: a clear promise to waive a right, reliance on that promise by the debtor, and as seen in DNC Builders v. Reese, it must be inequitable for the creditor to change their mind. If the debtor used pressure or took unfair advantage, equity will not help them. Finally, Combe v. Combe establishes that estoppel is a shield, not a sword. You can use it as a defense if someone sues you for the rest of the debt, but you cannot use it to start a lawsuit to claim a new right. Promissory estoppel doesn't destroy the original contract. It suspends the creditor's rights until it is fair to resume them. But consideration only matters if the person suing is actually a party to the bargain. This is the doctrine of privity. Historically, only the parties who signed the contract had rights under it. The Contracts Rights of Third Parties Act 1999 changed this, allowing outsiders to enforce a term if the contract expressly says they can, or if the term was intended to benefit them. This is why a subcontractor or a family member can sometimes sue for breach, provided they are identified in a contract by name, by class, like employees, or by a specific description. We also have to track agency. A principal is bound by a contract if their agent had actual authority to sign it, but they are also bound by apparent authority if the principal's own actions made it look like the agent was authorized, even if they weren't. To find the solution, we must determine not just what was promised, but who has the authority to make that promise and who has the standing to enforce it. The final hurdle is capacity. Even a clear bargain is unenforceable if a party lacks the legal power to contract. For example, the law generally protects minors by making their contracts non-binding. There are exceptions for necessities, things like essential food or clothing, and for beneficial contracts of service, such as apprenticeships that provide necessary training. In the Proform Sports Management case, a 15-year-old Wayne Rooney signed with an agent. When he later wiry, the upward bonus is binding because Barry secured a practical benefit under RAFI. The downward settlement is unenforceable under folks at common law, but Arcos may be protected by the equitable shield of estoppel if they can prove they relied on Barry's promise. A contract is more than a simple promise. It is a calculated exchange of consideration, confined by the limits of privity and capacity, and navigated through a matrix of common law rules and equitable defenses. Understanding this structure is how we determine which bargains the law will truly stand behind.